House Bill 5636, as approved by the House of Representatives on 31st of May 2017, income tax rate for individual citizens and individual resident aliens shall be as follows, effective January 1st, 2018, 2019, and 2020. Not over 250,000, 0%. Over 250,000, but not over 400,000, 20% of excess over 250,000. Over 400,000, but not over 800,000, 30,000 plus 25% of excess over 400,000. 800,000, but not over 2 million, 130,000 plus 30% of excess over 800,000. 2 million, but not over 5 million, 490,000 plus 32% of excess over 2 million. 5 million, 1,450,000 plus 35% of excess of over 5 million. Effective January 1st, 2021 onwards. Not over 250,000, 0%. 250,000, but not over 400, 15% of excess over 250,000. 400,000, but not over 800,000, 22,500 plus 20% of excess over 400,000. 800,000, but not over 2 million, 102,500 plus 25% of excess over 800,000. 2 million, but not over 5 million, 402,500 plus 30% of excess over 2 million. 5 million, 1.302, 500, or 1,202,500 and 500 plus 35% of excess over 5 million. After 2022, the taxable income levels and base in the above schedule shall be adjusted once every 3 years after considering the effect on the same of the 3-year cumulative CPI inflation rate rounded off to the nearest thousand. Section 22 and 24, definition of statutory minimum wage and statutory minimum wage earner, and the related provision on income tax exemption of minimum wage earner is removed. For self-employed professionals, no specific provision for self-employment and/or professionals in the old NIRC. Train Law added Section 24, A, 2, B, C, and D, whereby self-employed and/or professionals whose gross sales or gross receipts do not exceed the VAT threshold in Section 109, 3 million, will be subject to 8% income tax on gross sales or gross revenues in excess of 250,000 in lieu of percentage tax. Self-employed and/or professional whose sales or gross receipts exceed the VAT threshold in Section 109, 3 million, shall be taxed in the same manner as corporations as to the applicable tax rate, minimum income tax and allowable deductions as provided in Sections 27, letter A, 27, letter E, and 34 of the Tax Code. Professionals shall be required to present a certificate of tax payment from the BIR or certified true copy of their latest income tax return at the option of the taxpayer upon application for renewal of their respective professional license. 20% final income tax, Section 24B1, exemption of PC, SO, and lotto winnings, exemption of Philippine charity sweepstakes and lotto winnings from the 20% final tax is removed. Non-resident alien individuals who enjoy preferential income tax rates and employed by the following are removed. Non-resident alien individuals, Section 25 of the NIRC. Non-resident alien individuals who enjoy preferential income tax rates at 15% of gross income, salaries, wages, annuities, compensation, remuneration, and other emoluments included alien individual employed by regional or area headquarters and regional operating headquarters of multinational companies, offshore banking units established in the Philippines, and petroleum service contractors and subcontractors. So non-resident alien individuals who enjoy preferential income tax rate and employed by the following are removed. Regional or area headquarters and regional operating headquarters of multinational companies, offshore banking units, and petroleum service contractors and subcontractors. Taxable income defined, that's Section 31st. Removed from the definition of taxable income are the following: personal and additional exemptions and deductions authorized under special laws. The old NIRC says, Section 31st, taxable income defined. The term taxable income means the pertinent items of gross income specified in this code, less the deductions and or personal and additional exemptions, if any, authorized for such type of income by this code or other special laws. Removed from the definition of taxable income are the following: personal and additional exemptions and deductions authorized under special laws. Exclusion from gross income miscellaneous items, that's Section 32B, letter number 7, E. Section 32, gross income. B, exclusion from gross income, miscellaneous items. E, 13-month pay and other benefits, gross benefits received by officials and employees of public and private entities, provided, however, that the total exclusion under this subparagraph shall not exceed 82,000 pesos, which shall cover blah, blank, blank. The 82,000 threshold is increased to 100,000. Fringe benefit. Section 33. Special treatment of fringe benefit. A. Imposition of tax. A final tax of 32% effective January 1, 2000 and thereafter is hereby imposed on the grossed up monetary value of fringe benefit furnished or granted to the employee, except rank and file employees as defined herein, by the employer, whether an individual or a corporation, unless the fringe benefit is required by the nature of or necessary to the trade, business, or profession of the employer, or when the fringe benefit is for the convenience or advantage of the employer. The tax herein imposed is payable by the employer, which tax shall be paid in the same manner as provided for under Section 57A of this code. The grossed up monetary value of the fringe benefit shall be determined by dividing the actual monetary value of the fringe benefit by 68% effective January 1, 2000 and thereafter, provided, however, that fringe benefit furnished to employees and taxable under subsections B, C, D, and E of Section 25 shall be taxed at the applicable rates imposed thereat, provided further that the grossed up value of the fringe benefit shall be determined by dividing the actual monetary value of the fringe benefit by the difference between 100% and the applicable rates of income tax under subsections B, C, D, and E of Section 25. Effective January 1 of 2018 and onwards, the fringe benefit tax rate and the corresponding divisor used to compute the grossed up monetary value of fringe benefits are revised from 32% and 68% to 30% and 70%, respectively. 32% and 68% to 30% and 70%, respectively. Effective 2022 and thereafter, the fringe benefits shall form part of the gross income of the recipient employee, subject to the regular income tax rates. Deductions from gross income, Section 34 and Section 34A, number 1A. Section 34. Deductions from gross income. Except for taxpayers earning compensation income arising from personal services rendered under an employer-employee relationship, where no deductions shall be allowed under this section other than under subsection M hereof, is computing taxable income subject to income tax under section 24A, 25A, 26, 27A, B, and C, and 28A, number 1. There shall be allowed the following deductions from gross income. Letter A, expenses. Number 1, ordinary and necessary trade, business, or professional expenses. A, in general, there shall be allowed as deductions from gross income all the ordinary and necessary expenses paid or incurred during the taxable year in carrying on or which are directly attributable to the development, management, operation, and or conduct of the trade, business, or exercise of a profession, including letter I, a reasonable allowance for salaries, wages, and other forms of compensation for personal services actually rendered, including the grossed up monetary value of fringe benefit furnished or granted by the employer to the employee, provided that the final tax imposed under Section 33 hereof has been paid. Removed from those are allowed deductions from gross income are individual citizens and individual resident aliens in general, Section 24A. Included in those who are allowed deductions from gross income are self-employed and or professionals whose gross sales or gross receipts exceed the VAT threshold in Section 109, 3 million. On the allowed deduction of a reasonable allowance for salaries, including the grossed up monetary value of fringe benefit effective 2022 and thereafter, the actual monetary value of the fringe benefit and not the grossed up monetary value shall be allowed as deductions under Section 34. Optional standard deduction, Section 34L. L. Optional standard deduction. In lieu of the deductions allowed under the preceding subsections, an individual subject to tax under Section 24, other than a non-resident alien, may elect a standard deduction in an amount not exceeding 40% of his gross sales or gross receipts, as the case may be. In the case of a corporation subject to tax under Section 27A and 28A, number 1, it may elect a standard deduction in an amount not exceeding 40% of its gross income, as defined in Section 32 of this Code. Individuals may no longer apply the 40% optional standard deduction in lieu of itemized deduction. Premium payments on health and or hospitalization, Section 34M. Letter M. Premium payments on health and or hospitalization insurance of an individual taxpayer. The amount of premiums not to exceed 2,400 pesos for family or 2,000 pesos a month paid during the taxable year for health and or hospitalization insurance taken by the taxpayer for himself, including his family, shall be allowed as a deduction from his gross income, provided that said family has a gross income of not more than 250,000 pesos for the taxable year. Provided finally that in the case of married taxpayers, only the spouse claiming the additional exemption for the dependents shall be entitled to this deduction. Deductions for premium payments on health and or hospitalization of an individual taxpayer of 2,400 per family is removed. Personal and additional exemptions, Section 35 and 79D, 79F. Allowance of personal exemption for individual taxpayer. A. In general, for purposes of determining the tax provided in Section 24A of this title, there shall be allowed a basic personal exemption amounting to 50,000 pesos for each individual taxpayer. B. Additional exemption for dependents. There shall be allowed an additional exemption of 25,000 pesos for each dependent not exceeding 4. Section 35 on personal and additional exemption for individual taxpayers is repealed. Section 79D on the related exemption certificate and 79F on rule on claiming exception for husband and wife are also repealed. Exemption. Section 62. Exemption allowed for estates and trust. For the purpose of the tax provided in this title, there shall be allowed an exemption of 20,000 pesos from the income of the estate of trust. The 20,000 pesos exemption from the income of the estate or trust under Section 62 is removed. State tax. Section 84. There shall be levied, assessed, collected, and paid upon the transfer of the net state as determined in accordance with Section 85 and 86 of every dissident, whether resident or non-resident of the Philippines, a tax based on the value of such net state as computed in accordance with the following schedule. If the net state is over 200,000 but not over 500, 0. If it's 200,000, the tax shall be exempt. 200,000 but not over 500, that's 0, plus 5% of the excess over 200,000. 500,000 but not over 2 million, the tax shall be 15,000 plus 8% of the 500,000, the excess of 500,000. 2 million but not over 5 million, the tax shall be 135,000 plus 11% of the excess of 2 million. 5 million but not over 10 million, the tax shall be 456,000 plus 15% of the excess of 5 million. 10 million and over, the tax shall be 1.215, 1,215,000 plus 20% of the excess over 10,000 million. The state tax shall be 6% of the value of the net state. That's the new one. Computation of net state's deduction. Section 86. Computation of net state. A. Deductions allowed to the estate of a citizen or a resident. In the case of a citizen or resident of the Philippines, by deducting from the value of the gross estate. 1. Expenses, losses, indebtedness, and taxes, such amount. 4. The family home, an amount equivalent to the current fair market value of the decedent's family home, provided, however, that if the said current fair market value exceeds 1 million pesos, the excess shall be subject to estate tax, as a sine qua non condition for the exemption of or deduction. Said family home must have been the decedent's family home as certified by the barangay captain of the locality. Letter B. Deductions allowed to non-resident estate. In the case of a non-resident, not a citizen of the Philippines, by deducting from the value of that part of his gross estate, which at the time of his death is situated in the Philippines. The allowable deduction of the current fair market value of the decedent's family home is proposed to be increased from 1 million to 3 million, to be adjusted every 3 years beginning 2018, according to its current value, using a 3-year cumulative CPI inflation rate. Removed as allowable deductions to estate of non-residents are expenses, losses, indebtedness, and taxes. Removed is Section 86D on the condition required to allow the estate of a non-resident decedent who is not a citizen of the Philippines to claim deduction. Expenses, losses, indebtedness, and taxes. That proportion of the deduction specified in paragraph 1 of subsection A of this section, which the value of such part bears the value of this entire gross estate whenever situated, are removed. Letter D. Miscellaneous provision. No deduction shall be allowed in a case of a non-resident to a citizen of the Philippines unless the executor, administrator, or any one of the heirs, as the case may be, includes in the return required to be filed under Section 90 of the value of the time of his death and that part of the gross estate of the non-resident not situated in the Philippines. Donor's tax, Section 99, rates of tax payable to donor. In general, the tax for each calendar year shall be computed on the basis of the total net gifts made during the calendar year in accordance with the following schedule. If the net gift is 100,000, not over 100,000, the tax shall be exempt. But 100,000 but not over 200,000, the tax shall be 0 plus 2% of the excess of 100,000. 200,000 but not over 500,000, the tax shall be 2,000 plus 4% of the excess of 200,000. 500,000 but not over 1 million, the tax shall be 14,000 plus 6% of the excess over 500,000. 1 million but not over 3 million, the tax shall be 44,000 plus 8% of the excess of 1 million. 3 million but not over 5 million, the tax shall be 204,000 plus 10% of the excess over 3 million. 5 million but not over 10 million, the tax shall be 404,000 plus 12% of the excess of 5 million. 10 million and over, the tax shall be 1,004,000 plus 15% of the excess over 10 million. The tax shall be 1,004,000, I think. 1,004,000. B. Tax payable by donor if donee is a stranger. When the donee or beneficiary is stranger, the tax payable by the donor shall be 30% of the net gift. The donor's tax shall be 6% to be computed on the basis of total gift in excess of 100,000, exempt gift made during the calendar year. The provision in Section 99B of a 30% donor's tax on donations to a stranger is removed. VAT. VAT zero-rated sales of goods. Section 106, letter A, number 2. Section 106, value-added tax on sales of goods or properties. The following sales by VAT registered persons shall be subject to 0% rate. A. Export sales. The term export sales means the sales and actual shipment of goods from the Philippines to a foreign country, respective of any shipping arrangement that may be agreed upon, which may influence or determine the transfer of ownership of the goods so extorted and paid for in acceptable foreign currency or its equivalent in goods or services, and accounted for in accordance with the rules and regulations of the Bangko Sentral ng Pilipinas, BSP. Number 2, sales of raw materials or packaging materials to a non-resident buyer for delivery to a resident local export-oriented enterprise to be used in manufacturing, processing, packing, or repacking in the Philippines of the said buyer's goods and paid for in acceptable foreign currency and accounted for in accordance with the rules and regulation of the BSP, Bangko Sentral ng Pilipinas. Number 3, sales of raw materials or packing materials to export-oriented enterprise whose export sales exceed 70% of total annual production. Number 4, sale of gold to the Bangko Sentral ng Pilipinas. And 5, those considered export sales under Executive Order Number 226, otherwise known as the Omnibus Investment Code of 1987, and other special laws. And 6, the sale of goods, supplies, equipment, and fuel to persons engaged in international shipping or international air transport operations. B, foreign currency denominated sale. The phrase foreign currency denominated sale means sale to non-resident of goods, except those mentioned in Section 149 and 150, assembled or manufactured in the Philippines for delivery to a resident in the Philippines, paid for in acceptable foreign currency, and accounted for in accordance with the rules and regulations of the BSP. Letter C. Sales to persons or entities whose exemption under special laws or international agreement to which the Philippines is a signatory effectively subjects such sales to zero rate. VAT zero rated sales of goods in Section 106A(2) are revised as follows. Letter A. Export sales, Section 106. Item 4. Sale of gold to the Bangko Sentral ng Pilipinas is removed under export sales and listed as a separate VAT zero rated sale of goods as Section 106(2)(c). Item 6. The sale of goods. Item 6. The sale of goods, supplies, equipment, and fuel to persons engaged in international shipping or international air transport operations is qualified by the phrase provided that the goods, supplies, equipment, and fuel shall be used for international shipping or air transport operations. A paragraph is added in Section 106A, number 2, as follows. Provided that items 2, 3, and 4 of Section 106A, number 2A shall be subject to the 12% VAT and no longer be considered export sales subject to 0% VAT rate upon the establishment and implementation of an enhanced VAT return system, which gives the taxpayer the actual refund or denial of his application within 90 days from the filing of the VAT refund application. Section 2, 3, 4 of Section 106, letter A, number 2A refers to the following. Number 2, sales of raw materials or packing materials to a non-resident buyer for delivery to a resident local export-oriented enterprise to be used in manufacturing, processing, packing, or repacking in the Philippines of the said buyer's goods and paid for in acceptable foreign currency and accounted for in accordance with the rules and regulations of the BSP. Number 3, sales of raw materials or packing materials to export-oriented enterprise whose export sales exceed 70% of total annual production. Number 4, those considered export sales under Executive Order 226, otherwise known as the Omnibus Investment Code of 1987 and other special laws. Letter B, foreign currency denominated sales are removed from the list of VAT zero rated transaction. Letter C, 106, Section 106(2)(a), C is revised to read as follows. Sales to persons or entities whose exemption under special laws or international agreements to which the Philippines is a signatory. Definition of sale or exchange of services. Section 108, letter A. Value-added tax on sale of service and use of lease of properties. Letter A. Rate and base of tax. The phrase sale or exchange of services means the performance of all kinds of services in the Philippines for others for a fee, remuneration, or consideration, including those performed or rendered by construction and service contractors, stock, real estate, commercial, customs, and immigration workers, lessors of property, whether personal or real, warehousing services, lessor or distributors of cinematographic films, persons engaged in milling, processing, manufacturing, or repacking goods for others, proprietors, operators, or keepers of hotels, motels, rest houses, pension houses, inns, resorts, proprietors or operators of restaurants, refreshment parlors, cafes, and other eating places, including clubs and caterers, dealers in securities, lending investors, transportation contractors under transport of goods or cargoes, including persons who transport goods or cargoes for hire, and other domestic common carriers by land relative to their transport of goods or cargoes, common carriers by air and sea, relative to their transport of passengers, goods, or cargoes from one place in the Philippines to another place in the Philippines. Sales of electricity by generation companies, transmission and distribution companies. Services of franchise grantees of electric utilities, telephone and telegraph, radio and television broadcasting, and all other franchise grantees except those under Section 119 of this code, and non-life insurance companies except their crop insurance, including surety, fidelity, indemnity, and bonding companies, and similar services regardless of whether or not the performance thereof calls for the exercise or use of the physical or mental faculties. The phrase sale or exchange of services shall likewise include XX. The phrase sales or exchange of services shall include sales of electricity by generation companies, transmission and distribution companies, including electric cooperatives. Zero rated sales of services, Section 108B. Value-added tax on sale of services and use lease of properties. B. Transactions subject to 0% rate. The following services performed in the Philippines by VAT registered persons shall be subject to 0% rate. Number 4. Services rendered to persons engaged in international shipping or international air transport operations, including leases of property for use thereof. Number 5. Services performed by subcontractors and or contractors in processing, converting, or manufacturing goods for an enterprise whose export sales exceed 70% of total annual production. 6. Transport of passengers and cargo by air or sea vessels from the Philippines to a foreign country. VAT zero rated sales of services in Section 108B are revised as follows. Item 4 is revised to read as follows. Number 4. Service rendered to persons engaged in international shipping or international air transport operations, including lease of property for use thereof, provided that these services shall be exclusively for international shipping or air transport operations. Item 6 is revised to qualify air or sea vessels by the word domestic as follows. 6. Transport of passengers and cargo by domestic air or sea vessels from the Philippines to a foreign country. The following provision is added. Provided that Item B, 5 hereof shall be subject to the 12% value-added tax and no longer be subject to 0% VAT rate upon the establishment and implementation of an enhanced VAT refund system, which gives the taxpayer the actual refund or denial of his application within 90 days from the filing of a VAT refund application. VAT exempt transaction or Section 109. Exempt transactions subject to the provisions of subsection 2 hereof. The following transactions shall be exempt from the value-added tax. Letter D. Importation of professional instruments and implements, wearing apparel, domestic animals, and personal household effects, except any vehicle, vessel, aircraft, machinery, other goods for use in the manufacture, and merchandise of any kind in commercial quantity, belonging to persons coming to settle in the Philippines for their own use and not for sale, barter, or exchange, accompanying such person or arriving within 90 days before or after their arrival, upon the production or evidence satisfactory to the Commissioner that such persons are actually coming to settle in the Philippines and that the change of residence is bona fide. Sales by agricultural cooperatives duly registered with the Cooperative Development Authority to their members, as well as sales of their produce, whether it is in its original state or processed form, to non-members, their importation of direct farm inputs, machineries and equipment, including spare parts thereof, to be used directly and exclusively in the production and or processing of their produce. M. Gross receipts from lending activities by credit or multi-purpose cooperatives duly registered with the Cooperative Development Authority. N. Sales by non-agricultural, non-electric, and non-credit cooperatives duly registered with the Cooperative Development Authority. provided that the share capital contribution of each member does not exceed 15,000 pesos, and regardless of the aggregate capital and net surplus, ratably distributed among the members. P. Sales of real properties not primarily held for sale to customers or held for lease in the ordinary course of trade or business, or real property utilized for law, cost, and socialized housing as defined by Republic Act 7279, otherwise known as the Urban Development and Housing Act of 1992, and other related laws. Residential lot valued at 1,500,000 and below. House and lot and other residential dwellings valued at 2,500,000 pesos and below, provided that not later than January 31st, 2009, and every 3 years thereafter, the amounts herein stated shall be adjusted to their present values using the Consumer Price Index, CPI, as published by the National Statistics Office. Q. Lease of a residential unit with a monthly rental not exceeding 10,000 pesos, provided that not later than January 31st, 2009, and every 3 years thereafter, the amount herein stated shall be adjusted to its present value using the Consumer Price Index, as published by the National Statistics Office. U. Importation of fuel, goods, and supplies by persons engaged in international shipping or air transport operations. W. Sale or lease of goods or properties of the performance of services other than the transaction mentioned in the preceding paragraph. The gross annual sales and or receipts do not exceed the amount of 1,500,000 pesos, provided that no later than January 31, 2009, and every 3 years thereafter, the amount herein stated shall be adjusted to its present value using the Consumer Price Index, as published by the National Statistics Office. Removed from the list of VAT exempt transactions is item Q. Lease of a residential unit with a monthly rental not exceeding 10,000 pesos, supposed to be 12,800 under RR 16 2011. The following VAT exempt transactions are revised to read as follows. Item D. Importation of professional instruments and implements, tools of trade, occupation or employment, wearing apparel, domestic animals, and personal household effects belonging to persons coming to settle in the Philippines, or Filipinos or their families and descendants who are now residents or citizens of other countries. Such parties here inafter referred to as overseas Filipinos, in quantities and of the class suitable to the profession, rank, or position of the persons importing said items for their own use and not for barter or sale, accompanying such person or arriving within person reasonable time, provided that the Bureau of Customs may, upon the production of satisfactory evidence that such persons are actually coming to settle in the Philippines and that the goods are brought from their former place of abode, provided further that vehicles, vessels, aircrafts, machineries, and other similar goods for use in manufacture shall not fall within this classification and shall therefore be subject to duties, taxes, and other charges. Item P. Sale of real properties not primarily held for sale to customers or held for lease in the ordinary course of trade or business, or real property utilized for socialized housing as defined by Republic Act 7279, otherwise as the Urban Development and Housing Act of 1992, and other related laws. Item U. Importation of fuel, goods, and supplies by person engaged in international shipping or air transport operations, provided that the fuel, goods, and supplies shall be used for international shipping or air transport operations. Item W. Sale or lease of goods or properties or the performance of services other than the transaction mentioned in the preceding paragraph. The gross annual sales and or receipts do not exceed the amount of 3 million pesos, provided that not later than January 31st, 2021, and every 3 years thereafter, the amount herein stated shall be adjusted to its present value using the Consumer Price Index, as published by the Philippine Statistics Authority, PSA. Retained in the list of VAT exempt transaction is item B, sale or lease of goods and services to senior citizens and persons with disabilities as provided under RA 9994, Expanded Senior Citizens Act of 2010, and 10754, an act expanding the benefits and privileges of persons with disability. The following is added as a last paragraph under Section 109, provided that the sale of real property utilized for socialized housing under item P hereof shall no longer be an exempt transaction upon the establishment of a housing voucher system which shall benefit buyers of socialized housing. Section 116, Tax on persons exempt from VAT. Section 116, Tax. Any person whose sales or receipts are exempt under Section 109, letter B, of this code from the payment of value-added tax and who is not a VAT registered person shall pay a tax equivalent to 3% of this gross quarterly sales or receipts, provided that cooperatives shall be exempt from the 3% gross receipts tax herein imposed. Section 116 is revised as follows. Tax on persons exempt from value-added tax or VAT. Any person whose sales or receipts are exempt under Section 109W of this code from the payment of value-added tax and who is not a VAT registered person shall pay a tax equivalent to 3% of his gross quarterly sales or receipts, provided that self-employed and or professionals whose gross sales or gross receipts do not exceed the VAT threshold, and cooperatives shall be exempt from the 3% gross receipts tax herein imposed. Excise tax. Current and proposed tax rate summarized below. Manufactured oils and other fuels, Section 148. The rates of excise tax on the following are proposed to be increased effective January 1, 2018. For lubricating oils and grease, including but not limited to base stocks, for lube oils and greases, high vacuum distillates, aromatic extracts, and other similar preparations, and additives for lubricating oils and greases, whether such additives are petroleum-based or not, per liter and kilogram, respectively, or volume capacity or weight increased to 7 pesos from 450 pesos to 9 pesos in 119 and 10 in January 1st, 2020. Provided that lubricating oils and greases produced from base stocks and additives on which the excise tax has already been paid shall no longer be subject to excise tax. Provided further that locally produced or imported oils previously taxed as such but are subsequently reprocessed, refined, or recycled shall likewise be subject to the tax imposed under this subsection. For processed gas per liter of volume capacity increased to 3 pesos from 0.5 to 5 pesos in January 1st, 2019 and 6 in January 2020. For waxes and petroleum per kilogram increased to 7 from 350 and 9 in January 2019 and 10 in January 2020. For denatured alcohol to be used for motive power per liter of volume capacity increased to 3 pesos from 0.5 to 5 pesos in January 2019 and 6 in January 2020. For naphtha, regular gasoline, and other similar products of distillation per liter or volume capacity increased to 7 pesos from 4.35 and 9 pesos in January 2019 and 10 in January of 2020. For leaded premium gasoline per liter of volume capacity increased to 7 pesos from 5.35, 9 pesos in January 2019 and 10 in January 2020. For unleaded premium gasoline per liter of volume capacity increased to 7 from 4.35, 9 in January of 2019 and 10 in January of 2020. For aviation turbojet fuel per liter of volume capacity increased to 7 from 3.67, 9 in January 2019, and 10 in January 2020. For kerosene, per liter of volume capacity increased to 3 from 0 to 5 in January 2019 and 6 in 2020. For diesel fuel oil and on similar fuel oils having more or less the same generating power, per liter of volume capacity increased to 3 from 0, 5 in January 2019 and 6 in 2020. For liquefied petroleum gas, per liter increased to 3 from 0, 5 in 2019 and 6 in 2020, provided that liquefied petroleum gas, when used as a raw material in the production of petrochemical products, subject to the rules and regulations to be promulgated by the Secretary of Energy in consultation with the Secretary of Finance, per liter of volume capacity 0, provided finally that liquefied petroleum gas used for motive power shall be taxed at the equivalent rate as the excise tax on diesel fuel oil. For asphalts, per kilogram increased to 3 from 0.56, 5 in 2019 and 6 in 2020. For bunker fuel oil, having more or less the same generating power per liter or volume capacity increased to 3 from 0, 5 in 2019 and 6 in 2020, provided however that the excise taxes paid on the purchase base stocks bunker used in the manufacture of excisable articles and forming part thereof shall be credited against the excise tax due therefrom. For the period occurring 2018-2020, the scheduled increase in the excise tax on fuel, as imposed in this section, shall be suspended should the Dubai crude oil price reach $80 per barrel or more, provided that should the said oil price per barrel fall below $80, the scheduled increase in excise tax shall be implemented, provided finally that any suspension of the increase in excise tax shall not result in any reduction of the excise tax being imposed at the time of the suspension. Details. Mandatory marking of all petroleum products, Section 148AA, Current National International Revenue Code, as amended. No provisions on mandatory marking in the present tax code. House Bill 5636, Section 148A, is added to provide for mandatory marking of all petroleum products. All petroleum products, refined oil, and other fuel that are refined in, manufactured in, and or imported into the Philippines that are subject to the payment of taxes and duties, which include but is not limited to gasoline and diesel, shall be marked with the official marking agent designated by the Department of Finance. The marker shall be introduced at the refinery or at the terminal before the petroleum product is offloaded, or transported to the domestic market. Presence of Customs BIR officials, Section 148B, Official Markers, Section 148A. The mandatory marking of all petroleum products shall be in accordance with the following. Letter A. The person, entity, or taxpayer who owns or enters the petroleum products into the country, or the person to whom the petroleum products are consigned, shall cause and accommodate the marking of petroleum products with the official marking agent. B. A customer BIR official shall be on site to administer the declaration of the tax and duties applied on the petroleum products. Letter C. Official markers. There shall be a list of chemical activities and corresponding quantitative ratio for each type of fuel to be identified by the Secretary of the Department of Finance as official fuel markers. The official fuel markers shall be distinct and to the greatest degree possible immune to imitation or replication. The official fuel marker used in the Philippines must not be used in any part of the world. The official markers, chemical composition, and quantitative ratio must persist for at least 3 years from their application or administration to the unmarked fuel. Absence of marker presumptions, Section 148A. D. Prosecution of offense, Section 148A. E. Random field test, Section 148AF. D. The absence of official marker or use of fraudulent marker presumptions. In the event that the petroleum products which do not contain the official marker are found in the domestic market, or in the possession of anyone or under any situation where said petroleum products are subject to duties and taxes, it shall be presumed that the same were refined, manufactured, or imported, or withdrawn with the intention to evade the payment of taxes and duties due thereon. The absence of the official marker or the use of fraudulent marker on the petroleum product shall be considered prima facie evidence that the same have been withdrawn or imported without the payment of the excise tax. Letter E. The failure of any person, entity, or the taxpayer responsible for the marking of the petroleum products are required in this section shall be prosecuted under Section 265A of this code. F. Random field tests. Periodic random field tests shall be conducted on fuels found in the warehouses, gas station, and other retail outlets, and in such other properties or equipment, including mechanism or transportation of persons engaged in the sale, delivery, trading, transportation, distribution, or importation of fuel intended for domestic market. The field tests shall be conducted in the presence of a representative from the BIR or BOC, third-party marking provider, and the authorized representative of the owner of the fuel to be tested. For purposes of this act, an employee assigned or working at the place where the field test is conducted shall be deemed an authorized representative of the owner. All field tests shall be properly filmed or videotaped and documented. The customs or BIR shall immediately obtain a sample of the tested fuel upon discovering that the same is unmarked, adulterated, or diluted. Confirmatory test, Section 148A(g). Program Implementation Office, Section 148A(h). Powers and duties of the PEO, Section 148A. Number 1, marked in the bill as F1. G. Confirmatory test. A confirmatory test of the tested, unmarked, adulterated, or diluted fuel shall immediately be conducted in an accredited testing facility that is certified by ISO 1725. Confirmatory fuel test certificates issued by fuel testing facilities shall be valid for any legal purposes from the date of issue and shall constitute admissible and conclusive evidence before any court. H. Program Implementations Office, PIO. There shall be a PIO headed by a DOF senior officer to be designated by the Secretary of Finance and with the Commissioner of Customs and the Commissioner of Internal Revenue or their duly authorized representatives with the rank of Deputy Commissioner and one senior officer each from the Department of Energy and the Department of Trade and Industry to be designated by the Secretaries of DOE and DTI, respectively, as members that shall directly coordinate and supervise the proper and effective implementation of this act. The PIO shall be supported by the personnel of the DOF as well as those assigned or seconded from agencies attached to the DOF. The PIO shall have various powers and duties, including the following. A. Formulate, develop, and establish a comprehensive, integrated, unified, and balanced national fuel trafficking prevention and control strategy. 2. Promulgate rules and regulations necessary to carry out the purposes of this act. 3. Design and develop special training for law enforcement officers, members of the judiciary, and prosecutors on knowledge and know-how in fuel trafficking and smuggling. 4. Initiate and authorize closure proceedings against non-accredited and or substandard fuel testing facilities. 5. Evaluate all information on the information, sale, transfer, delivery, or distribution of unmarked, diluted, or adulterated fuel intended or held for domestic market. 6. Conduct bidding, give accreditation, and engage a third-party marking provider. 7. Perform oversight function over the third-party marking provider. 8. Appoint and engage technical, administrative, and other personnel necessary for the effective implementation of this act. Call on any official of the Department of Energy and its attached agencies for necessary assistance, as well as require experts to help achieve the objectives of this act. Number 10. Initiate criminal, civil, and or administrative actions in the proper court or quasi-judicial agency for violations of this Act. 11. Submit monthly progress report to the Secretary of Finance and annual report to the relevant committee of the Senate and the House of Representatives. And 12. Establish an extensive media and public information campaign to inform the public of the importance of fuel marking and its expected economic benefits. The PIO shall submit to the Secretary of Finance the following: A. Specifications of the national marker. B. The marker to be used and the marking service provider. C. Terms of reference and engagement of the provider. D. Performance measure of the program. E. Sports places where the fuel marking program will be rolled out. Engagement of third-party marking provider. Section 148A J. The PIO shall engage a third-party marking provider, not more than one, which shall provide an end-to-end solution of the government. Example, providing monitoring and administering the fuel markers, provide equipment and devices, conduct field and confirmatory tests, and perform such other acts incidental or necessary to the proper implementation of the provisions of this Act. The third-party marking provider should not have any customers in the Philippines beside the government. Costs. Section 148A. All costs in relation to the implementation of the provisions of this section shall be borne by the refiner, importer, or manufacturer of petroleum products. Definition of terms as used in this section. The following terms shall have the meaning indicated. Chemical diversion refers to the sale, distribution, supply, or transport of legitimately imported, in transit, manufactured, or procured, controlled, precursors and essential chemicals in diluted mixtures or in concentrated form to any person or entity engaged in fuel trafficking, and shall include but is not limited to packing, repacking, labeling, relabeling, or concealment of such transaction through fraud, destruction of documents, fraudulent use of permit, misdeclaration, use of front companies, or mail fraud. Number 2. Confirmatory test refers to an accurate and precise analytical test using a device, tool, or equipment which will validate and confirm the result of a field test. Deliver or transport refers to the act of knowingly passing fuel of commercial quantity to another person and by any means with or without consideration. Field test refers to the random inspection and test performed to establish qualitative positive result of the fuel trafficking. Fuel, as used in this section, refers to any combustible gas or combustible liquid that can be used to generate power by means of an internal combustion or turbine engine, or for heating, and include additives to that fuel except jet fuel, aviation fuel, and liquefied fuel, petroleum gas. 6. Fuel markers refer to official markers identified by the Secretary of Finance that is administered or mixed into a particular fuel in order to distinguish it from other types of fuel or unmarked fuel of the same type. Fuel marking refers to the addition or administration of additives to fuel in order to distinguish it from other types or fuel or similar unmarked fuel. Fuel trafficking refers to the sale, trade, delivery, distribution, or transportation of unmarked, diluted, or adulterated fuel or counterfeit additive, the act of diluting or adulterating marked or unmarked fuel, or any related acts designed to circumvent this section. Importation refers to the entry of fuel products, or additives in the Philippines through the seaport or airports as determined by the Bureau of Customs. The fuel products, or additives being intended for direct consumption, merchandising, warehousing, or for further processing. Manufacture refers to the production, preparation, compounding, or processing of any fuel or petroleum products for sale, trade, distribution, or transport. The term does not include the preparation, compounding, packing, or labeling of a fuel product, or additive by a duly authorized practitioner as an incident to his or her professional practice, including research, teaching, and chemical analysis of fuel or fuel additives of such substances that are not intended for sale, trade, delivery, distribution, or transportation. Marked fuel refers to the fuel that is marked in accordance with the provisions of this Act. Person refers to any entity, natural or juridical, including, among others, a corporation, partnership, trust, or estate, joint stock company, association, syndicate, joint venture, or other incorporated organization or group capable of acquiring rights or entering into obligation. Sell or distribute refers to any act of giving away any fuel, fuel products, and or additives, whether for money or any other consideration, and whether as private sale or sale to the consuming public. Testing facility refers to the testing lab operated by the accredited third-party marking